Greetings and welcome. This is Steve Ball here. I am waiting for. There we go. All right. Invite. Add. Ladies and gentlemen, this is Mr. Lomtevas, attorney at law, family law attorney, and we're going to have a conversation about, the overall runs and wrongs of family law and some things that he's noticed within the family law reform movement, and I'm going to also say the family rights movement. And I know that he's, we talked just briefly for a few moments. I know that he's got some concerns about some things that he's hearing, and I said, you know what, let's bring those concerns to the public and let's talk about it with the audience today for a little bit. And he agreed to come on. Again, he is a practicing attorney, and he is a family law attorney at that. He knows the system inside and out. He knows what's going on here. And so, Peter Lomtevas, thank you for joining me today. I
You're,
appreciate it very much.
you are most welcome. Thank you for having me.
All right. Well, usually, we would do this on the show, but you know what? I just want you to just kind of take a few moments and kick back a little bit and just tell me, what you see is going on. Go.
Well, I have spent probably 3 months listening into the conversations that the Americans are having about family court and divorce court, and certainly they're sharing experiences. Under the First Amendment, we're allowed to associate and we're allowed to speak and we're allowed to share our experiences without anybody's permission. There's a certain line out there that we cannot cross, and that line is the practice of law. That requires an okay from the government, particularly the judicial branch. So when we have video conferences where people are giving tips to other people, what to say to a judge to get a child, or to maybe keep a child from an opponent, or maybe minimize or maximize a child support calculation, a community property distribution, or an equitable distribution, where we've crossed the boundary into the practice of law. And please don't forget, this is not my humble opinion. I'm not the one sitting here deciding who is committing the unauthorized practice of law violation. It is the hostile prosecution and the hostile court that are going to be making the decision or conclusion or verdict or sentence on a person. Typically,
Mr. Lomtevas, I'm sorry. Right off the bat, I'm being asked to ask you a question, if I may. The question is, ask him if he up front tells his, end quotes, clients surrounding their constitutional rights by paying him to enter maritime admiralty law jurisdiction, question mark, doubt it.
Well, I mean, this is ridiculous babble. There is no maritime jurisdiction. In family court, we're not an ocean and we're not a Titanic. This is a state civil court, probably at the lowest level, to reach the greatest number of people. Yes, my clients have to pay me because it's a legal service, just like you have to pay your transmission repairman if you want your transmission to be rebuilt. Certainly, the obligation of the transmission repairman will be very different than the obligation that I'm going to have to my client. But I have to zealously represent, I have to think of the client's best interest, and I have to accomplish results. And my 17 years in practice says something of the fact that I have been generally successful in this practice, protecting people's access to their children.
Well, I think there's some concern there, and I've heard this before. I think there's some concern there where we might say, look at the gold fringe around the flag. That's not my flag. My flag does not have a gold fringe. And I think that leads other people to think certain things. Would you be willing to make comment on that?
Well, I'll make a comment on that, but that whole gold fringe thing is not my understanding at all. What I think these people are actually doing is they're doing their own historical knowledge a major disservice. They're trying to read case law, and there are very many attorneys, many years in practice, who have trouble reading case law. It's very compact and codified and encrypted knowledge that takes a while to unpack. It seems that back in the 1750s or 1760s, Courts on dry land could not hear issues arising on ships. So if there's a tort action, half of which happened on the base and half of which happened on the ship, the district court of that district could not hear or did not have jurisdiction over things happening aboard the ship on the ocean. So there was a court case, and I believe it went all the way up to the Supreme Court, that held that a district court has the authority to hear cases that involve issues of quote unquote maritime law. So if somebody punched somebody in the face on a ship and continued punching that person on dry land, now the federal court can hear both the punches that happened on dry land and on the ship. And that meant that the person who got punched couldn't have two bites at the apple. He couldn't go back to the ship and use the courts aboard a ship. That was, in other words, there was a unification of jurisdiction that took place. And this is being misunderstood as being some sort of an application of maritime law in a family setting. And that is perfectly absurd.
Okay. So I appreciate that answer. I accept that answer. That sounds okay in my mind, as a reasonable layman. That sounds logical. It sounds like it made sense. Look, we've also got parents that are coming on here, and they're talking to, more well-known activists and advocates in the family rights movement, and they're hearing, file in 1983, 42, file in DC jurisdiction, file this, file that. And I'm sure you've heard some of these same arguments to file. What's your take on some of this as a practicing attorney? In good standing, in your state. I'm curious.
Well, all of this talk about filing here and filing there is just as ridiculous as applying maritime law to a family court. Family court system operates on a statute. There's a statute that delineates a person's due process rights. Everything that's in the statute, that's what you get. What does that mean? That means that those marble columns and that marble edifice, you can't knock it down. You cannot say that, the family court judge was incorrect. I'm going to now run to federal court and I'm going to win on a civil rights case. No, you will not. Your civil rights case. All right, Peter,
just go ahead and keep talking. I'm just going to slide you in my pocket for a minute, and I'm going to go get set up there at the desk. Just go ahead and keep going.
Your rights in federal court are tissue thin. You'll be dismissed. Family court problems and issues cannot be brought in case to be dismissed. To run to a state legislature, that's like running to a fox to complain that another fox raided the hen house. That legislature wants the federal money, so your state politicians are not going to pay attention. So you only have two ways to attack the snake. You either attack the snake through its head or you attack it through its tail, not in the middle. That means that you have to know what you're doing. You cannot be outmaneuvered. You have to take the case all the way to the very end, and you have to appeal it if necessary. And the other end would be go to the president and have the president veto reauthorizations of the various acts that have brought all this misery upon all of us. The Child Support Standards Act, these Child Support Enforcement Acts, the Violence Against Women's Act, the Adoption and Safe Families Act, and all of these various other acts that are essentially a federal preemption of our rights, but we cannot file any kind of summonses and complaints for a redress of grievances arising from those acts. We can't do it. So we have to get it right inside the courtroom, or we have to convince the president to veto much of this legislation so that we starve the snake.
Okay, a commentator says here, I hold land rights, which gives me standing on the common law, unless you tear down my great-grandmother's national monument on the Oregon Trail.
Well, I mean, again, we're talking absurdity, okay? There's a piece of land standing has nothing to do with the loss of one's child in a family court or in a divorce court.
Okay. Are we still there?
Yes, I am.
All right. Just trying to get set up here because I want to type in a few things while I talk to you, we're going to give out some great information today. And I appreciate you coming on board and having this conversation with me. I really, really do. I usually have here somewhere so I can set my phone and work off my computer. Let's see if I can come up with what I want for like a stand or something. So another thing that another thing that we hear a lot about in this movement, and we hear it all the time. We hear about social services not being commissioned law enforcement. We hear that they have no authority. We hear that they don't have an oath of office, and then we also hear the same thing about judges, where where we might say, where was the judge's oath of office? How could the judge act against me and my family when he's not a real judge? Where's his oath of office? What right do you have, judge, or do you even call yourself a judge? We hear this all the time.
Well, this is the other major problem facing challenges to this system. What you're describing is the sovereign citizen problem. The sovereign citizen means that's the person who is his own leader, and he can go up to a judge and ask for the judge's credentials, and then question the judge's jurisdiction, and question the judge's integrity, question everything about the judge. That doesn't work. You get yourself arrested if you try to play the sovereign citizen. The judge was either elected or appointed by political leaders or by the public. Here's an emergency. A kid needs money. Here's a deadbeat father, presumed to be deadbeat. We're going to fleece him. We're going to shake him down. We're going to get money to feed the kid. There are no ifs, ands, or buts. Remember, we took on a zero tolerance policy somewhere in the 90s. We got sick and tired of crime taking place. We got sick and tired of people malingering and people being deadbeats. And we're now going to have the zero tolerance approach. And that's what we're seeing. And that judge has the authority. That judge can impose whatever the judge wants to impose and get a person into royal trouble with his landlord, his employer, and his spouse.
So we see this. I looked this up just so that we can have the audience here understand this. So I typed in personal jurisdiction, and then here's what I get. Subject matter jurisdiction refers to whether a court can hear a case on a particular subject and is usually pretty clear. Personal jurisdiction, on the other hand, refers to whether a court has power over the person being sued and can be difficult to determine. I think there's a lot of there's a lot of commentation on that. I think there's a lot of debate on whether a court can actually apply the jurisdiction, whether you actually give the court permission to apply the jurisdiction. As an attorney at law, I would be honored if you would touch on that.
Well, you're touching upon the sovereign citizen again, but before I get into
Sure.
sovereign citizen, let me see if I can explain the difference between subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction is that piece of the pie that the court holds within which it can decide cases. A traffic court can decide traffic tickets. A housing court can decide landlord-tenant issues, ejectment actions, housing preservation petitions, and so on. Family court can decide somewhere up to 24 separate petitions, adoption, guardianship, people in need of supervision, juvenile delinquency, custody, child support. Okay, that's subject matter jurisdiction. You cannot take a child support case to a traffic court. You cannot take a housing court case to a family court. So that's subject matter. Personal jurisdiction, you've been served. If you've been served, the court now has personal jurisdiction over you. We are a service country, not a filing country. In other words, filing the papers with the court is not enough. That paper must now be served. Personal in-hand service for that initial pleading. That's the rule in most of the 50 states, in most of the 3,000 counties. It's federal law. It has to happen. Otherwise, the problem is that if there is that order arising under a non-served complaint or petition, a motion to vacate that judgment for failure of service is effective. And whatever that judgment is goes away. Even whopping child support arrears can be eliminated if that original petition was not, quote unquote, properly served. So if you have a really good challenge to service, you're going to walk away with owing nothing. But you have to know what you're doing, certainly. And there is a professional process service corps out there ready to serve you. Now, here comes sovereign citizen. I've just been properly served with a pleading. Here I have my pleading. It's got the backing. I've just been served in hand. Your Honor, you have no jurisdiction over me because I didn't grant it to you. Well, that sovereign citizen argument may get you locked up for a direct contempt of the court. So that would be horrific advice to tell somebody to say that. You can't. The court has
Okay,
jurisdiction. You've been served.
here's another one that I hear about, and I love how you just illustrated that. Here's another one that I see a lot, and I got to be honest with you, sir. I may have actually done this myself. Okay, so here's where I'm at. When we're talking about issues of child support, and we're talking about the right to owe versus the right to collect, and there's so many facets to it. Okay, but we also hear a lot. The 14th Amendment gets drug out quite a bit. I am not a slave. You cannot indenture me. I do not owe this because I have a right to be poor, and so do my children. Okay, and then we end up finding these arguments against Title 4D, and as much as I hate Title 4D, I think in its inception it had a great platform, but overall what it's done is to serve to destroy. However, when you tell that to various people that receive child support, and they look at you and they say, I pay my light bill, I get Johnny and Susie shoes, I put food on the table, I give them cable, I pay the cell phone bill, Johnny Susie's got new coats, Johnny Susie has school supplies. It really makes it a hard argument. But we hear this 14th Amendment all the time in this. May I ask you to put your take on that?
Well, it's really not the 14th. It's really the 13th, slavery. Are we allowed to be indentured or enslaved?
Oh, did I say, I'm sorry. Yeah, okay. Go ahead. 13th Amendment. I said 14, didn't I?
13. Well, okay. Well, this is a confusion of issues. Let's see if I can break out the confusion of issues. Okay, number one, there was a welfare state. President Reagan was the governor of California. Too many people on welfare, broke the budget. Became the president. Too much welfare, broke the budget. We need to find a solution to welfare. The single mom with the kid have to be supported by daddy. And in that time frame, everything was a crisis. Everything was a priority. Everything was an emergency. So what arose out of a cure for welfare was this zero tolerance attitude toward fathers who aren't supporting their kids. We're talking broke men, broke women living in projects with no hope, and we were going to now take them to court, and we were going to flip them upside down and pour money out of them. That was the original idea. Then comes Clinton in the 90s, and they pass or sign a piece of legislation that applies child support enforcement upon every American. That's your support collections unit, the driver's licenses, professional licenses. That arose under the Clintons. So here we are today, zero tolerance. You're a deadbeat dad if you're not paying. All of that arose from a political mind fake. And yes, indeed, the man has to have the calculation made out of his pre-tax money, has to be paid out of post-tax. So he goes really broke. And the order of support given to the mother in most cases is insufficient to feed a cat. And that's how it goes in the United States. We have this interconnecting network of people paying child support to each other. For what real purpose? Well, for the state to get its Title 4D matching fund in order to maintain the enforcement apparatus. This is the government spawning subordinate organizations and basically feeding off the public. And Ronald Reagan, who brought us all this, at the same time said that we have to watch out for big government. We need to shrink government down in order to enjoy the blessings of freedom. And we have the exact opposite today. That's my explanation.
When we're talking about, and again, I hear this all the time, this subject comes up, and I appreciate your explanation, I really do. We're talking about, in some cases, the statute of limitations on child support. Would you mind touching on that?
It varies widely from state to state. The statute of limitations is not the totality of the payment at the time of the entry of the order. The statute of limitations marches on. Some states have a 20-year statute of limitations. So if there's an order entered in the year 2000, all of those payments can be enforced up until 2020. When we go into the first month of 2020, that very initial payment from 2000 falls away. So there's a constant marching 20-year period, As 1 month progresses, 1 month falls away. One comes in, one goes out. That's how the statute of limitations works in the majority of the states. Some states have 6 years, some have 10, some have 15. New York has 20. So that means that you could be hounded for 20 years after the age out of your child, which in New York is 21. So for a total
20,
of 41 years, you could be hounded. And to me,
20.
that's a lifetime.
Okay, so that's 20 years. What is that? What is that 20 years? What is that?
Let's suppose for a moment that we have an order of support at the time of the baby's birth, and the child's support is being paid all the way until the age out of the child. Somewhere
Uh-huh.
along the line, the non-custodial parent is no longer able to pay. Let's say that 10 years before the child's age out, the non-custodial parent loses his job, loses an arm, and the typical child support court refuses to lower the order. So that means that 10 solid years of arrearages build up. All of those 10 years are enforceable for another 10. But then as each month after that maximum statutory period, as each month progresses after that, then those initial payments begin to fall away and are no longer due and owing.
Well, hold on 1 second. Ladies and gentlemen, for those of you guys coming on board, we are talking to Peter Lomtevas, attorney at law. And I realize we're getting lots of questions here. No disrespect to you, Peter. I'm going to read off some of these comments. Pamela, excuse me, Pamela Olson says, I think I'm going to say this right, for every dollar paid in child support, ordered or voluntary, the state gains a matching dollar from federal funds under Title IV. Marking money for states has no less than 8 ways to siphon funds off, says Seymour. To siphon funds off federal taxpayer dollars. Talk about state welfare! Exclamation mark. And then she says, shaking my head. Now, Peter, we hear this all the time as well, both on RFIR. I mean, I've been on multiple other shows as well as a guest host, and a commentator. And, I hear that the state just gets money hand over fist for these social services cases, and not only social services cases, but also these parent versus parent cases where we're being forced to allocate child support from one parent to another. Would you be willing to make, or do you know if you can make comment on this?
There's a tremendous amount of confusion out there. I hear people saying that the original child support amendments came in the 60s, and some came in the 70s, some came in the 80s. Government support of the poor has always been there, and government protection of children has always been there. But as Reagan warned, that the closest thing you'll ever see to eternal life on earth is a government bureaucracy, this entire Title IV and child support enforcement is nothing more than a giant government bureaucracy. It lost its way. And it all seems so legal from the government's point of view. This is simply daddy giving money to the child. But nobody ever notices a kind of a more devious use of this system. A very wealthy person can sign a lot of money over without a gift tax to a non-spouse and a child. Very wealthy people love child support. They're actually able to pass a tremendous amount of money to non-relatives using child support. But as far as what we're seeing here, we're seeing a focus on the common working person. And the common working person is indeed, he's paying tremendous taxes to run a system that's there to jail him if in the event he doesn't support his child. So it's a mind fake on top of a ripoff.
Now, when you go and represent these cases, if you don't mind me asking, and I think it's worthwhile for the audience to hear, okay? We're talking about a plethora of issues. We're talking about multiple facets. So I understand that there's no one size fits all. There's no glove that says, I get it, okay? But when you run these arguments against the court, what's your success rate? And how many of these totalitarian support enforcement orders are we able to either minimize, overturn, or modify?
Well, in my own practice in the state of New York, if I can get into the case at the very, very beginning, and I'm representing the non-custodial parent who is almost always the father, I make absolutely certain to prep the person for child support. One of the most important things that we do is we prepare a financial disclosure. Some states call it an I&E, some call it an FDA, whatever, it's the financial disclosure. Because what happens is without an attorney, a young person walks in and just shrugs his shoulders and says, I'm broke, I have no money. But the statute anticipates that and then is able to impute income upon a person who is now deemed to be refusing to present his income figures. What I'm saying is the vast majority of child support damages take place in those initial appearances where a person doesn't understand the law. The law compels him to disclose. So people working off the books who don't have an accurate accounting end up with an imputed income amount. Those people who are fairly well off, who run private businesses, who have minimal W-2s, they're fantastic. So when a client comes to me with a petition, we don't have an awful lot of time, to massage the numbers in order to prepare a financial disclosure. What do I mean by massaging the numbers? Well, in many jurisdictions, New York included, the court wants to see the last 3 pay stubs. Yes, I'm going to tell the client, look, don't work triple overtime, because then what the court will do is they'll annualize that overtime and then base a support amount on that annualization.
That very same thing has happened to me, sir, and I didn't even know that it was happening when it was happening. It just happened to be that during the time of my life that this was going on, I was indeed catching a lot of overtime at my job. The boss said, "Look, you're going to need a lot of overtime. I'm gonna provide as much as I can give you at this time because you're going to have some expenses, court fees, filing fees, things like that." Not ever knowing how bad that was going to come back and bite me, because when the prosecuting attorney got a hold of it, they said, "Oh, you are capable of making this much money." And I said, "Well, actually, no, that's all overtime, so I could come here and deal with this mess." My boss had a little bit of a heart, but it screwed me. So what's the?
Well,
Go ahead.
the vast majority of these situations turn out this way. There's another rule in the statute, the Child Support Standards Act, that your child support payment is not based on what you earn. It's based on what you can earn. And that's where this idea of imputation comes in. And this is where these support courts are able to pull numbers out of the hat. Now, I am reading some of the commentary that some people are writing. I certainly, I take it very offensively. I have one person here who says that I'm a straight up liar. Well,
Well, you okay,
I know this
Mr.
individual
Lomtevas, you're an attorney at law. You're an
doesn't
attorney at
practice
law.
law. Yeah.
And, right, and so you know what? Whether I agree or disagree, let us both agree as professionals in our field that some people are going to disagree. They've been screwed by attorneys or feel they've been screwed by attorneys.
Well, that's I understand that. I do see one comment here: imputed income can be successfully appealed based on no finding of intentional evasion of support. Well, that's wrong. And why is it wrong? It's wrong because we have a vertical integration. Government stood up like a pillar from top to bottom. What does that mean? That means in order to maximize daddies paying mommies for their kids, the appellate court is not going to look at an imputed order and say, "Oh my God, that is wrong. We're going to reverse that."
Right. We're going to get right on that. Right.
So a lot of these comments are hokum. They come from folks who don't know the law, and they don't want to know the law. But from my perspective, okay, when I actually go into a courtroom, I find an underjudge, I find a conciliator, magistrate, master, I find a court attorney making decisions as to people's money. And then there's a chance to file a set of objections to a reviewing judge who will virtually never overrule one of these court attorney, magistrate, conciliator, master people. Now, of course, you're going to get a final order that is whopping, and then you're going to go to your local appellate court and you're going to try to appeal, and you're going to find that judgment is affirmed. You can also do something else. You can go back and file for a modification, and good luck doing that. So the best advice that there could be is to know the law and to be very, very well prepared. And remember that the state stands on the opposite side of the transaction. The state is not a neutral arbiter. the state stands on the opposite side of the transaction to make those Title IV-D funds. So they're going to work their operations in such a way to get the maximum number of dollars on that order of support. And for those folks who think they can reverse it or they can overrule it or they can appeal it, they can go spin their wheels and hate lawyers some more. Lawyers are out
Mr.
there to make
Lomtevas,
money. They can hate them.
I have nothing but appreciation for your time here. I'd like to read an excerpt out of one of these law books that I have. Again, this cross claim or counterclaims is this is a reoccurring theme. We hear a lot about it. Let me get through just these short two little paragraphs, and I want to offer the audience some honest truth about this, because we hear this going back and forth all the time. I'm sure you see it as well. So this is what the book has to say, and I'm curious how you would say it in real terms, practicing law in front of his or her honor. Okay. At times, defendants themselves have a claim and are entitled to some relief from the court. They may be asserting this claim against a plaintiff, co-defendant, or a third party, someone who is not a party to the original action. Okay. In federal court, when defendants assert a claim against a plaintiff, it is known as a counterclaim. When the claim is asserted against a co-defendant, it is known as a cross-claim. Finally, when the claim is against a new party, it is known as a third-party complaint. Counterclaims and cross-claims are included with the answer, but third-party claimants are pleadings that are separate from the answer. See Table 6. We're not going to get into all that. Okay. Regardless of which form the defendant claim takes, the content of the claim is the same. The content of the defendant's claim for relief is similar to the content of the plaintiff's claim in the complaint. I'll stop right there. So a lot of times when we're talking about child support, we see this, well, he owes me for the last 5 years for this, that, and the other, and then dad comes in there and says, yeah, but I paid for school, I paid for daycare, I paid for the medical expenses. You know, and they file these cross claims. They do all the time. When the court looks at this, in your experience, how does the court equal all this out and be equitable?
Well, first of all, I don't know of any child support courts that entertain cross claims or third party claims of any kind. It is 99% custodial parent versus the non-custodial parent to get an initial award or to enforce. There will always be petitions by the non-custodial parent to try to modify downward, and guess what? You'll find the majority of those are going to be completely dismissed. Otherwise, it's a one-sided operation. It's like in electronic circuitry. It's a diode. The current only flows in one direction.
One direction, yeah.
You do raise some points about litigation. I'm reading some of the commentary, and the commentary it's very illuminating actually. Money buys justice in this system. If a father who just got screwed, having to pay a whopping order of child support, has the money to go up on objections and then to do an appeal, file the brief, file the record on appeal, conduct an oral argument, and then reverse something, money buys justice. The typical American father just simply doesn't have that kind of money. And at about the 12-year mark, when custody typically flips in the United States, where the mother loses the child, then the mother discovers, oh my God, I have to have a fortune to navigate the system.
Hold on. We're getting a comment here. Bottom line, hire an attorney who has a better relationship with your judge. Okay, then Pamela Olson states, why is it the courts involved in all child support claims? ? Only those within, it keeps moving. I lost my place, sir. Only those within criminal intent should be brought before a real court, not an admiralty kangaroo court. Most parents successfully co-parent without state interference. No parent should get screwed in a system with skin in the game. Hold on. Pamela, we discussed, I don't know if you were on here just a little bit ago, but Mr. Lomtevas did talk about the Admiralty Court and why it's set up the way that it is and what it was supposed to do. So after I post this video, go back and listen to maybe the first 10 minutes or so, um, 15 maybe, and you'll find that answer, at least as far as the Admiralty Court goes. Um, as far as the other question, I will ask the same question to attorney at law, Mr. Peter Lomtevas. Why are these courts injecting themselves in these family law cases I want to say in the numbers per capita that they are?
Well, you understand it's all our fault. I mean, as a group of American citizens, we brought this all upon ourselves entirely. There was a time we were complaining that welfare mothers were driving Cadillacs, and politicians heard this. And we hear this in dog beating cases. You beat up a dog, let's string up the person. Well, we don't string them up on a tree. We throw them on a criminal court calendar to get a felony conviction if it's a companion animal. We all know about child rape. How do you respond to child rape? It's a visceral reaction. We really need to put that person in front of a judge. Well, we had that attitude about welfare a long time ago, and we basically did it to ourselves. There was a time 30 years ago where a mother or a father could go to a welfare office, get a check, get WIC, get a voucher for Section 8, and there were virtually no courts involved. Maybe an admin law judge would make a decision if there was some kind of a fraudulent conveyance or use or manipulation of the system. So Americans stood up, went up to the plate and said that we need to get, tough on this zero tolerance policy. And somebody had the bright idea, we need to get courts involved. And I find that to be the most ridiculous thing one can imagine. For mom to get $100 a week, she has to spend $5,000 on a lawyer to go to a court. How can we be saying that we're supporting our children? We're supporting me. We're not supporting our children. Don't blame me. I didn't think up the system. I simply represent people. But the money comes fast and hard by moms who need money for their kids, and by dads who need to pay less because they can't afford to live. So Americans created it, and we're going to be creating more. What are the latest? What are the latest equal gender? We're going to now have prosecutions for people who discriminate on a gender base. We're going to have prosecutions for people who hold gays in contempt. I mean, we're, you hear on the news, gun control. We're now going to give death penalty to shooters. This all involves a court. This involves whopping sums of money to accomplish really very little. Let the punishment fit the crime. Don't make an example of everybody. Courts it's like a conveyor belt. The court sees the thing and then stamps it and it moves on. There's no individuality. Nobody looks at the facts anymore. And
I agree with you there. Look, I want you to take this next comment from Pamela. I have to admit, I'm not familiar with the Mondale Act. You may be. I don't know.
To be quite honest, I sometimes have to go online to remember what happened. Mondale should be. It's back in 76, 77, 78. Jimmy Carter was president, and Walter Mondale was his vice president. And it was in that time frame that the Child Abuse Prevention and Treatment Act went on the books. Apparently, Americans were beating their kids, and battalions of these children were walking the streets begging for help. So the federal government just had to get involved with a national standard. And right now, mothers are losing their children as a result of the national standard. Prevention, treatment means psychologists. Who hasn't had a psychologist in his child abuse case, right? Treatment,
sure, yes.
Those are your therapists. Oh, we're going to send a kid to therapy, $200 an hour therapy, all for nonsense. So that's right. The Mondale Act. That's CAPTA.
Okay, so the Mondale Act kicks in the 70s. I realized that you weren't practicing law at that time. I think you were still in the military,
I was 14 years old in 1974.
Oh, okay. All right. I thought you were a tad bit older than that. But correct me if I'm wrong, you are a military veteran?
I am.
And you served at the rank of captain?
That's correct. I was
Okay.
separated from active duty at the rank with the rank of captain.
Okay. All right. Thank you, sir, for your service. I appreciate it very much.
My pleasure. Thank you.
Okay. Cinnamon White says, I have heard some new advocates claiming family courts violate the RICO Act. And she would like to know, sir, what is your take on the RICO Act?
Well, we know RICO is Racketeer Influenced Corrupt Organizations Act, and that was enacted by Reagan. The idea there was the capo, who's the boss, orders a hit. Before RICO, we couldn't get the capo. Now we can get the capo. So it's a vertical integration assault mechanism to knock everybody out. No, the government is not a racketeer influenced corrupt organization. We voted politicians in to feed children. No child should be left unsupported. No child should be left in danger. No child should sit in foster care for years and years and years and not be adopted. We're the ones who enacted all of this. And we cannot sue a judge under the RICO statute. There's absolute immunity. And the reason is the judge didn't write the law. We wrote the law. We have to repeal the law. We have to eliminate that law. Maybe we have to take these statutes away from the court system and maybe send them to administrative agencies. So that way judges aren't, brought to the forefront to have to make these terrible decisions.
I love it. Thank you. We're getting another one here. What about ARRA or ARA grants? Again, I am not familiar. I've heard, but I'm not familiar. So we'll have to look this up.
I think that it's let's see. I also have to look these things up. There are 50 states and there are different statutes. What I'm seeing here is American Recovery and Reinvestment Act of 2009. This legislation provides an unprecedented level of funding to help stimulate the U.S. economy through the support and advancement of scientific research. Okay, a very brief history. Okay, Ronald Reagan takes the presidency, and there's an immediate problem with inflation. The value of the dollar is going down a little bit too much. Remember that 10 years prior, Nixon took away the gold standard and made the dollar stand on its own. And there were many factory workers. They were making a lot of money. They were buying products. The price of products was going up as a result. And now we had this problem with inflation. Reagan brings in Paul Volcker. Volcker introduces the 20% federal tax rate. That's the prime lending rate, slowing the economy to a stop, completely to a creep. Through the 90s, we had a little bit of terroristic activities, a little bit more activity in the stock market, and then all of a sudden, everybody decided real estate. We're going to invest in real estate. So in the zeros, President Bush turns up the heat on real estate, and we all know about the 2008 crash. So here comes President Obama, and this act and many other acts, they called it the stimulus, were intended to put Americans back into their homes, get them into their cars, going to work again, get that economy back on track, pretty much the way Franklin Delano Roosevelt had it. Unfortunately, it didn't work very well because homes were now $1 million, $750,000. Gasoline was $4 a gallon. There was OPEC with all of its various embargoes in the 70s and 80s and price increases. So these various acts typically failed. They failed to accomplish their intended results. And in fact, they created a society where, there's the wealthy and there's the poor. And the poor are really poor. And of course, the wealthy have these policy initiatives. We need to protect kids. We need to support kids. And the wealthy become presidents. They become congressmen. And then they impose their will on the common person. And the common person is angry. The common person is very, very angry. Read some of the notes here on this video feed. That's the result of anger. And I understand it. So that's my take on recovery acts.
Interestingly enough, I think there's some definite argument to be made here. Because look, we've got a Democrat-Republican issue, we've got funding, we've got fiduciary responsibilities and things like this. What is your take at that point with the fiduciary coming in as part of that recovery? I know a little bit about it, you know. So they
I
were
don't.
supposed to be like ombudsmen in the beginning, or how did that work out?
No, I don't. I don't understand fiduciary. I don't understand how that relates to an economic recovery. We're talking about the law and courts.
There you go.
Okay?
Thank you.
Fiduciaries have nothing to do with the court system. You're either an attorney or litigant or a judge or a court officer. There's nothing else in there. And courts have nothing to do with economic recovery. They have to do with law enforcement, whatever the law is that we happen to enact as a public.
All right. Thank you. Now, we also hear this quite a bit. And again, this is not a challenge to you, at least from me in any way. Okay. We're just, you know, talking to an attorney who practices law in the state of New York. He's an attorney in good standing, represents cases on a regular basis, stands there, talks to the courts, writes motions, you know, pleadings, filings, the whole 9 yards. Okay, so we hear I have a right to my children because they are my property. My children are my property.
No, they're not. Children are not your property. Children are not our property. When the Constitution was written, you have the right to life, liberty, and property. That property meant your land. It did not mean your children. It did not mean your furniture. It did not mean your automobile in more recent years. I don't understand where we get this notion that kids are our property. The government has a doctrine called parens patriae, where the government is the parent of the children. That means that if the biological parents fail in any way, a judge determines that they failed, the government simply comes in and takes over. Now, we voters would need to eliminate parens patriae, and we might need a constitutional amendment that makes children our property to do with as we please. But until that happens, children are not our property. I understand in all the comments, everybody's freaking out. This is wrong. This is wrong. This is the current state of the law. Why not change the law instead of
Well, you
suing the
said, you know
judge
what,
for
you
RICO?
had said too, and I think it's important to reiterate for the audience here, which seems to be fluctuating a lot, which, I mean, this is not my main Facebook account. I tried to share this over to my main Facebook account where we could get the bulk of my audience, our audience, and many members of the movement. But this will be shared, you know, all over the place, I'm sure. Look, when we're talking about the judicial branch of our government having control, you know, isn't it safe to assume that Congress, our representatives, our state and federal leaders are the ones that tell the judges how to delegate their power? You know?
There it's a seesaw. There have been times when the judiciary was the third branch of government making independent decisions. Then sometimes it seesaws the other way, where the Congress does the talking. They walk the walk and they talk the talk, and the judge better react. I personally prefer it the other way. I prefer the judiciary to be a feedback mechanism. If a law is screwed up, then Congress needs to fix it, to unscrew it. Otherwise, if the judge is a yes man or a yes woman, rubber stamping all of this garbage, Congress doesn't know that something doesn't work. And that spawns this movement across the country, the sovereign citizen movement, to overthrow government and to establish a whole new order, which I thoroughly disagree with. It's much easier to give the judges back their independence so that they can hear the cases, they can make the law fit the case, and then notify Congress by reversals, strikings based on unconstitutionality, and whatever other mechanisms to show Congress that their laws are screwed up, they should be repealed or they should be amended. Right now, that system is broken because of zero tolerance and probably this attitude of, well, the rich run the show and the poor people are there to be taken advantage of.
Okay, well, okay, so the people are there to be taken advantage of. I know, and I'm not beating up on this individual. But there is an individual within the movement, and I have a certain respect for him. But he does have a loss prevention to stop people from being taken advantage of. It seems. I'm curious on what your take on that legal theory is.
Well, again, I did not write the law. A person becomes an attorney based on the rules and standards set forth by the typical state's judicial branch. It's the judicial branch that determines whether a person is qualified to be a lawyer. The judicial branch does not have half lawyers, quarter lawyers, one-tenth lawyers, partial lawyers. They don't have loss prevention specialists. They don't have firefighters. They don't have garbage cleaners. There's a license to practice granted by the judiciary for the person to practice before the judiciary. It's like basic training before a soldier can go to a military unit. It's like
Right.
police academy before a person can become a cop. You can't just put a person into a uniform, hand him a gun and a badge, and tell him to go. He has to be trained first to operate within a force. And that's what law licensure does. So all of this idea, loss prevention and prevent criminality by the court, all of this is a contempt citation, is all what it is. And there is no sovereign citizen who can come in and represent somebody to protect against losses of some sort. That's a contempt. It also could be an unauthorized practice of law, and it could be a felony indictment, depending on the hostile jurisdiction that person finds himself in.
Okay, let me and this again, I am not arguing with you. I am not, in any way, shape, or form. But this is something rather new here in Washington State. You may not be aware of it. I would like to take a moment and read this to you. I know that this idea is catching on fast. I just want to get your take on this, okay? In Washington State, we have passed something called a limited license legal technician, which means paralegaling licensing on its way. Okay. Paralegals often face questions about the extent and limitations of their role in the legal system. These parameters are poorly defined in most states, leaving a substantial gray area that has caused many people to call for professional licensing laws that would help to better delineate what work or what legal work a paralegal may or may not perform. The term substantive legal work may be one that's used often in the field, but it lacks a clear universal definition that everyone agrees on. Now, here we go. LLLTs don't necessarily have significantly more training than any other paralegal, but they have significantly more freedom. Removed from the requirement to have a lawyer supervising their work, they have the freedom to open their own offices, set their own rates, and provide legal advice to clients as they see fit. Their clientele are largely middle and lower class people who otherwise would have no representation in civil matters, including divorces, child custody hearings, and matters of domestic violence. Although these are pedestrian issues for lawyers, they involve major life-changing matters for clients. Triple LTs can expect to make a big difference for clients in ways they could not have as normal paralegals. LLLTs have to be mindful of the limits of their role. They have a carefully defined list of prohibited activities, and they have to be comfortable referring clients to lawyers for matters outside their areas of purview. Now, here's what they're supposed to be. This is what the outline is supposed to be. The requirements to become a limited license technician in Washington State are: obtain an associate's degree or higher, complete a 45 credit hours or core curriculum in an approved legal program, complete applicable practice area courses offered by the University of Washington School of Law, complete 3,000 hours of substantive paralegal experience under supervision of a lawyer, take and pass a practice area and profession responsibility exam. Although the family law is currently the only recognized practice area covered under the rule, many paralegals see expansion into this as inevitable. Mr. Lomtevas, as an attorney, what are your concerns about this area?
Well, how would you like to have open heart surgery by a doctor technician? Let's replace your aortic valve with an assistant, a technician. Would you like? That would work great, wouldn't it? Or how about I take my automobile to an auto mechanic who has an assistant technician tech all over my car? All right, I like the notion of sublicensure, but I see a something devious. I see something not quite all there by having these technicians, walking in with their pens and pads into a family court case. Family court is where all the abuse is taking place. That means we're going to take a poor person and we're going to make it simpler to take the baby away from the poor person. The tech will say, give the kid up. So not only are you not getting zero for your dollar, you're losing. And this is the problem with free representation across the country. You're actually paying through the teeth for your free representation by losing everything.
To lose, right? You're paying to lose. Yes.
So on the one hand, I see the problem is that our legal system, believe it or not, is very highly over-regulated. To become a judge, to become a lawyer, the 50 state boundaries, all of the piles of papers that are involved, the statutes. A technician, who read a couple of pages is not going to be fully aware of everything that happened in the past the way an attorney would who had to study for a typical state's bar examination. So we have to be prepared in a variety of areas. I cannot make a criminal defendant settle on a domestic violence charge without knowing the ramifications in immigration law. I better know that that person isn't going to be deported. I also better understand the impact of a guilty plea on a person's ability to get custody, on his ability to earn $1 to pay child support. I have to have all these calculations, taking place in my head. What are the chances of total disaster here, and how can I minimize total disaster? I don't think a technician hacking away at your chest, changing your aortic valve is the solution. I think maybe free legal education is the solution. Maybe if we send attorneys to law school for free, their prices would really drop. Right now, it's $50,000 a year minimum to go to a law school. And by the time that attorney comes out, he's ready to take that money to pay back for all that education. Maybe it's time to have more government legal schooling, and then perhaps programs that provide inexpensive housing and maybe paychecks to help people to pay off that education. I mean, make it really work with an incentive to help rather than have an incentive to personally enrich. So for all of these reasons, I think Washington's LL whatever program will be a total disaster for the hapless poor person who walks into a family court. That's what I
Yeah,
think.
you can find this. You or anybody can go to the Washington State Bar. You could go to the Washington State Bar page and type in legal definition LLLT for technician, and you'll find it there somewhere around June 28th or so. But no, I happen to agree with you. You know what? When I first came across this, I thought, oh my god, I do like their education requirements. However, like you said, these guys are not. They are not full-on attorneys. Now, I'm not going to say that somebody who's been a paralegal for the last 20 years, 15, 20 years, hasn't picked up a lot of knowledge along the way. In many ways, they could act like an attorney. They probably know certain things like an attorney would know. But at the end of the day, like you said, they have not proved that knowledge against the bar. And that could be detrimental. Really, it could be. And that's one thing I like what you're going with this. Regardless of what we hear or we said in the past, are you going to have a medical technician more or less perform heart surgery, or somebody who has a mastered knowledge of that particular a knowledge base or skill set? So I really appreciate the way that you put that. But this is something that's coming up. I wonder if that ties into this fiduciary, and I say it that way not out of disrespect for its quote-unquote creator, but this fiduciary law practice that I'm hearing so much about. I'm hearing so much about there's a mathematical equation that somehow applies, although it seems all a little bit above my pay grade, more or less, to understand it all.
Well, I see those calculations being publicized online as well. All of the fundamental assumptions are incorrect. Ordinarily, what happens with these calculations is the person doing the calculating separates the law from the court. That's how these calculations start. You have the law, you have the court, and then you have squiggles all around. The problem is that believe it or not, as hard as this is to believe, the court is the law. The court implements the law. And where there's a hole, the court is going to fill in the hole. The court can actually put a gap filler in there if there's something missing and needs to be filled in. Maybe some question of equity or fairness.
Well,
Or
but we
maybe
run into a situation where we say, well, judges are legislating from the bench, and I don't want to get too far off from that other thought pattern.
remember that that's how it was in merry old England 1,000 years ago. Judges created law. Legislature came later. Original law involved trespass. I have a piece of property, person came on my property, that was a case in trespass. Those are your initial court reporters are developing the law of trespass. And then as people began moving closer together and throwing snowballs at each other, throwing punches at each other, the law had to expand in order to prevent chaos, in order to prevent murder in the streets. There had to be a more orderly approach to dealing with infractions. And then came the trespass on the case.
Right.
So then judges could hear a little bit more than just trespass on the land. And then over the course of time, all these law libraries developed, and it became too much to fit in the head. And then a lot of judges were perfectly incompetent. And then the legislature had to step in and say, okay, we're going to do this, and this way. And of course, the judge is bound by the statute. Nobody says the judge isn't. But still to this day, what happens if there's a problem that the statute doesn't quite cover, the judge fills in the hole, and that becomes the law of the case. So yes, they manufacture laws as they go along. That's their function.
We get a lot of conversation in the movement, and have been for years, on procedure. And I'm glad that this conversation can just go rolling right into the next one here. So, that they didn't practice procedure, they violated my rights, and oftentimes the judges are going, I followed our court's procedure to the letter. Well, I'm going to file an appeal, damn it, because you didn't blah blah blah. Okay, file your appeal, and then the higher court says the court followed the procedure. There's no appeal here. Have a great day. We hear this all the time. So when we're talking about courts with local rules and then civil procedure, well, how can you have a court in Florida with following the same civil procedure codes as a court in New York, but their case won and my case didn't? Okay, we hear this all the time.
Well, I skim just the iceberg. Okay, the bulk of the iceberg is under the water. So the very tip of the iceberg typically is the first error in procedure a court will make is that a court will find jurisdiction where none exists. In other words, there's no affidavit or proof of service. The plaintiff or petitioner standing there saying, I had the person served. And if it's like, for example, a child support court wants the person to win, I find jurisdiction and the respondent defaulted. That's a big procedural faux pas. That's a big one. And these support courts, they do that all the time. That's a huge procedural error that leads to an order that could be vacated. But what senior judge is going to vacate such an order where the state is on that side of the transaction getting Title 4D money to do the enforcement? Getting down into the water, into that big chunk, our courts are absolutely guided by rules of procedure. Every step of the way is guided by procedure. The books are huge and thick, packed with deadlines and the kinds of documents that are needed and time frames and individual actions, the kind of motions that can be filed. And something, just like monkeys in a cage, okay, screaming for that banana, they're gonna go all over each other. They're gonna make mistakes. One person's gonna rule one way, another person is gonna rule another way, and these behaviors form the basis of why law is so inconsistently applied across the country.
Thank you.
It boils
Okay.
down to judicial competence, is what it boils down to. That's really it. Does a judge know pleadings? Does a judge know motions? Does a judge know discovery? Does a judge know trial practice? Does a judge know an objection when he hears it? These are what make that difference between New York and Florida. Maybe New York courts are a little bit more proficient. Maybe they're not. But these form the groundwork for how to explain differences involving virtually identical fact patterns and almost the same sums of money.
Well, when we're talking about that, when we're talking about those patterns, I want you to go into a little bit more, if you don't mind.
Go into what more specifically?
The patterns, when you're talking about these attack patterns, I want you to.
Well, attack patterns, we don't want to attack anybody. Okay, we're not attacking. The way to guard against it is to avoid settlement and to take a case to trial and then appeal it. But then again, what client is able to afford that? That's not easy. Now, if a judge makes a blatant mistake, like the judge stands up and throws his gavel at a litigant, well, that's a judicial canon violation, and that's a complaint against the judge to his commission
I'll come to
on
your
judicial
comments in a minute.
conduct.
Just let Peter finish talking. I promise you guys, I'll come to your comments. Go ahead,
Yeah,
Peter.
so that's the you don't attack. You actually have to set up the case to challenge the case. If you see mistakes being made, the more mistakes, the better the appeal. That's how to operate, and it takes skill and talent, which costs a mint. And
Yeah,
not
it's going to
every
cost. It's going to cost a little bit of money here. We have a comment here. When an attorney, we got a couple comments. I'm going to go through a couple of these, and I appreciate for your time this afternoon, sir. It's very, very,
Sure, my
very,
pleasure.
very nice of you. Okay, when an attorney can record date of jurisdiction of being acquired upon filing of response rather than process of service in complete violation of statute and get away with it, that is not enforcing the law, exclamation mark. That's one comment. And then I've got Pamela Olson again, and her comment is not giving parents their court case, not allowing let's see here, not allowing innocent until proven guilty. Concerns, worries by social entity are all equal, and nationwide procedure with these courts unconstitutional. You want to take which one you want to take?
Well, all right. It says here when an attorney can record date of jurisdiction being acquired upon
I'm not sure.
filing.
I'm not sure where the commentator's going with that at all. I'm
I
not sure.
suspect. Here's what I suspect: a general response to this and these kinds of questions. When a person is severely burned by the court system, they try to rationalize what happened, and they realize, wait a minute, the court system operates on books and law and procedure. Let me read about it. So they begin to read things, and they don't quite understand what it is they're reading, because there are very many different courts to accomplish very many different objectives. If it's a child support court where the mother comes in needing money for the baby, there's a very high probability that the support court is going to find jurisdiction, even if the mother served a garbage can. Is it wrong? It is very wrong. But does it happen? It happens every day. If it's a tort action against the city and the judge is getting an income from the city, that was the Larry Fine situation in California, where judges in one of the cities in California were getting a supplemental paycheck and were therefore very kind toward the city. A person filing an action against the city, serving up a proof of service, would be denied. Oh, you didn't serve the person properly. I don't find proper jurisdiction. It's all very variable, and it's gaming. And that's what happens. And the other thing that I've been noticing is when people are reading these statutes, they become very well versed in the law. And it's actually very impressive. I have people coming to me and telling me it's $10, not $5. And I go, yeah, you're right. That's right. It's 10. But that's not the issue. The issue is, how is the court going to react to the 5 or the 10? It's not how am I going to react. It's what's the court going to do? Is the court going to buy it and agree, or not buy it and disagree? Remember that a court is the final arbiter of the record. If the court looks at that proof of service and decides the person wasn't served, you have to go and reserve. If the court decides that whatever service you gave, garbage can or not, is good service, they'll mark on the record the service complete. Court has jurisdiction. So it is very variable because the system is just so complex. All right, I have another one here. Their only law is discretion, and their only procedure is to line their pockets with hard-earned tax dollars. I don't know how to respond to that. It's a business, it's an industry. Everybody's in it to make money. We have the 2% with all of the power, 98% being fleeced, and nobody's stopping this freight train. So this is going to simply keep happening. Moral turpitude is a crime, and any public officer who does not speak up is aiding and abetting. But you see, the whole idea is here's a person who read the rules and is properly quoting the rules. But there's
moral
nobody's going to
turpitude
listen.
it's a doctrine. There are things that moral turpitude activity can do to bring you to crime, but
She's not using that in the form of like an immigrant doing an act which is morally turpitudinous.
Okay, let's say I'm a police officer, and I pull you over. My probable cause for pulling you over might be personally biased, okay? Now, did
How
I
about
commit
reasonable suspicion? Your
right?
reasonable suspicion to pull me over was a speeding.
Sure, but at the end of the day, when you show me the reasons why and you explain there was a dog right there, I sped around the dog, whatever it was, and I look at it and I'm like, okay, but I'm gonna write you a $10,000 ticket for that. Now you have a moral turpitude issue. You could go back and have me taken to internal affairs and looked at for that. Okay, but at the end of the day, I'm still a law enforcement officer. I'm still in charge of the scene. I'm still writing you the ticket, and you still have a diligent duty to obey me as a commissioned law enforcement officer. Moral turpitude can become a crime, but in and of itself, it usually
But
isn't.
again, I don't believe this writer is using moral turpitude as a term of art. I think the writer is saying that here's a crime or here is a misconduct. See, Your Honor, look, here's a misconduct, Your Honor. And what does the judge do with this? Tosses it away. That's what the writer is referring to. And yes, that does happen. And how do
Yes.
you stop it? You can't.
Now,
Appeal.
okay, of course I want to get onto this. I want to get onto this other commentator. But look, what about going to like we hear there are many different names for them: board of special responsibilities, judicial review boards, commissioner sanction committee, or whatever they are. There's 5 or 6 or 7 different terms for the same group throughout the United States. You go there and you say, Your Honor, Judge Lomtevas, when I was in his court, he told me that he didn't like me because I had white skin and green eyes or whatever it was. It's terrible. I can't get a fair trial with this guy. Nothing. So I'm going to take you to the Judicial Review Board. Okay. But these judicial review boards do nothing. And this is a fact. 2% of the cases that go before them are actually dealt with. So many. I mean, can we all be wrong?
Well, again, we're talking of vertical integration. Do you understand what I mean by vertical integration?
Sure.
Of vertical
Yes.
integration, it's a hierarchy. Okay, it all flows downhill. If a judge is making money for the state using federal legislation, then that judge is the breadwinner or the rainmaker for that vertical integration. Complaining on that judge is going to get a person nowhere.
Thank you.
If
Go
the
ahead.
judge stands up and starts screaming and cursing at a litigant, then that judge will have a document put into his performance file and will probably not be reappointed because of that type of misconduct.
Right.
But the
Well, we've
judge
got
is
a very
smart.
good comment here. Pamela says, "Thank you, Steve Ball, for a great, spirited, informative debate interview. Thank you for your guest." Again, ladies and gentlemen, this is Peter Lomtevas, attorney at law, staying and answering our questions and statements. Well, Peter, I have to say the same thing here. I appreciate you coming on, board with us today and talking to us and answering these questions. I know how outlandish they may seem to somebody, once you have the education and the knowledge and experience. But we are talking, with quote unquote laymen. Some of us have college education, but we don't practice law like we think we can. And I appreciate for your time to come here and answer some of these questions.
You're
Go
most
ahead, though.
welcome.
Well, go ahead and finish your point there, if you don't mind.
Well, as you know, as I'm saying, the vertical integration, it's a great protective mechanism for people who are in it. The judge is earning an income and feeding a family. He's not going to make a mistake. He's going to bring in those federal dollars. And the issues before him are very simple. They're all the same. Father not supporting a kid, mother abusing a
What
kid needing a custodial parent. They can flip a coin,
comments
behind themselves
and
to make that
behind
determination. As long as they don't
missing?
show that they're flipping a coin, then their
Mr.
decisions will be upheld.
Lomtevas, I am being told on my other messenger over here that I am missing comments. Maybe you can see them on your screen, but I'm sorry if I'm not reading comments that I'm not seeing. I'm sorry.
I'm on the
I would
cell phone. I only see 3.5 comments.
right. I'm not. Yeah, I don't know. With all due respect, I don't know what comments I'm missing.
I have
So
one person telling me, tell your lies to someone else. Well, again, if a person is a sovereign citizen thinking that, he's in charge, then certainly everything I say is nonsense. But I come from within those walls. I practice this every day. This is my profession. I see the mistakes and I'm quite open about it. And I'm not lying. I'm telling you how it is. I mean, I'm not fantasizing or creating a story. I have my own client base that yeah, I better succeed in, or else I'm going to be out in the street.
but yeah, you're not going to be. Yeah, I mean, this is your bread and butter. That you better win some. You better win
Yeah,
something for somebody. You
yeah.
know, I mean,
I, I,
if you don't, like, if you were a bad mechanic, I take my car to you twice, and I say, hey, it knocks, it bangs, it clinks, it tinks, it sputters, it jitters, whatever, and you don't fix my car at least once, word's gonna get around. Dude cannot fix car.
Now, I do have another comment that I see here. Bottom line: find an attorney who kisses the judge's every body part. That's it. All right. Well, there is a saying that a good judge knows the law. I'm sorry, a good attorney knows the law, and a great attorney knows the judge. But indeed, there are ethical rules. The judge has to recuse if the attorney is familiar with the judge. So we cannot kiss judges' body parts. In reality, we really have to present strong cases, either to minimize damage or to maximize a win. So no, you want to have an attorney who's very reasonably priced, who's available all the time, and who knows his material, and has a track record of success, and they're out there. Maybe the public needs to find better ways to find lawyers. Maybe going down to quote unquote Court Street is the wrong way to do it. Maybe you need to use use
Let me
Google.
ask you this: do you think that it would be appropriate? And of course, I've got some other things going on. Do you think it would be appropriate to have more than one American Bar Association?
I kind of don't like this whole bar thing at all. I can't stand it. If I have a client who loses a child to Kentucky, I cannot go to Kentucky and litigate to get the child back. I'm stopped at the border. I hate that. I think we should have all one national license. I think there should be a partnership between the Department of Education and perhaps the legal side of it. But the main thing we have to protect against is clicks. We have to protect against the good old boy networks that are set up, where you lose this one, you'll win that one. You lose this one, you'll win that one. That goes on everywhere in these little tiny puddle towns across the United States. In the bigger cities, it's just bigger stakes. There
Mm-hmm.
bigger, more money changing hands, more
Right,
favors being done.
right.
But this entire licensing process that we have in the United States, I think it's absolutely ludicrous. I think it should be
Okay.
one national license. I think any normal person should be able to acquire it. I don't like the elitism. Only certain people of certain economic backgrounds can obtain it and maintain it, and that cannot be. There's no diversity in it. There's no honesty in it, and no utility in it. People are losing their families.
Somebody is saying, okay, I'm getting comments here rolling in. My screen's just moving fast. Okay. Somebody says you're lying, plain and simple. I'm not sure what. you're supposed to be lying about. And then they tell you to finish the comment, quote unquote, it's about you. And then I have another comment. It says American Bar Association equals guild. State by state guilds are, I don't know this word and I'm actually educated, an anthem to constitutional rights and protections.
An anathema,
Okay. Okay.
cutting against the grain of the Constitution. Well, that's
Oh,
ridiculous.
come on. Yeah. Okay.
Well,
Go
well,
ahead.
that's absolutely ridiculous. If I'm a commissioned officer on active duty in the Army, I better have gone through some sort of training, and I better wear a uniform, and I better keep improving. So to say that the bar members are members of some sort of a guild and guilds have been outlawed 1,000 years ago, I mean, again, that's that maritime sovereign citizen delusion.
Right.
That it's licking the wounds is what it is. A person is telegraphing that they've been destroyed by the system, trying to rationalize and figure out how that happened. It happened because Americans brought it upon themselves. They simply wanted to throw all of their personal problems into a court of law, and this is the result. We need to get it
Right.
back out. That's the fix.
Now we've got Cinnamon White right here who says, would have saved me a fortune. And she puts that in bold caps there. A fortune if lawyers could cross practice in states without pro hash.
Well, you understand, pro hoc vici is like
There we go.
My cousin Vinny. I have to come into a state,
Pro
and
hoc.
I have to
Okay.
have a sponsor. I have the client has to pay twice. I might be a specialist in child protection or in divorces. Person has to fly me in and have another attorney there and waste time and money, and it all should be made uniform. It's the same civil procedure state to state. All it has is different section numbers. But the citizen is the one getting screwed. And you know how the mind fake operates? You have to have a license in your particular state so that the citizen can depend upon you to know the law of the state. That's the mind fake. So what happens if somebody absconds with someone's kid to another state? Up, you need another attorney in that other state. And guess what happens? You lose your kid and you lose all your money. It should be one license for all 50 states. And if judges don't like that, maybe we need to vote new judges onto the bench.
Hold on here. I would prefer to not have an even more socialist federalist society. Sorry, not sorry. And then Crystal Malmstrom is asking you, what is your specialty?
Well, our entire conversation has focused in on matrimonial and divorce law. So that is my specialty, but that would be inaccurate to say that I limit my practice to only custody and child support. I have people coming in who hired me for a divorce. I find myself now in their real estate world. I find myself dissolving their corp, forming their corp, doing federal cases for them, labor law. In other words, domestic relations forms a foundation upon which the rest of my practice is built. And I better know those other areas. I better know criminal law, that's domestic violence. I better know housing law, landlord-tenant, how to do a closing, how to purchase a property. So all of these areas, my clients rely upon me to be able to function in, and I do.
All right. So okay, we've got Miss Howard coming on to join us. Thank you, Julie. It's a pleasure. I'm not gonna keep this man for too much longer. We've been chatting for quite some time now, but hopefully we can come back in the near future and have another one of these little Q&As if that's all right with you, sir.
Sir,
All right.
certainly.
Angela Craig Wiley, what about their oath of office to uphold? Okay, excuse me. What about their oath of office to uphold the constitutions? Question mark. It seems family court lawyers and judges don't do this.
Well, I'm looking at an attorney oath of office. An individual except the president elected or appointed to an office of honor or profit in the civil service or uniformed services shall take the following oath. I, Peter, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, and then it goes on. That's our oath of office.
Would you be willing to send me the attorney's oath of office there?
I could. I would have to. The
Yeah,
link is
I'm not
Cornell.
saying that I need your certificate or anything. No, no, no.
No,
I'd
I'm
actually like to
saying
see it.
it's on Google. Just Google attorney oath of office, and you'll get the oath of office. But my losing a criminal case does not mean that I sullied the Constitution. You
Right,
know,
exactly.
if a litigant hires me after 10 appearances, after he's lost everything, and I can't mitigate his damages, I'm not violating the Constitution, and I'm not ripping off the client. The client should have hired me at the very beginning. And that goes back to a question that I just read. Why do we have attorneys? Well, because it's complicated. We're a nation of laws, we're told, and it's complicated. There are books and there are precedents. We want to be able to run government in such a way so that we can predict how it's going to act. And that takes the learned mind, kind of, having studied all these ins and outs to be able to interpret it and be able to apply it. So the very simple answer is you need attorneys because all of this jazz is just way too complex. We're busy fixing cars. We're busy piloting aircraft. We're busy doing contracting work. We're building homes. We don't have time to read case law and precedents on a domestic violence issue. We hire somebody to guide us and advise us, and hopefully we won't get too screwed. There's this big misunderstanding out there that the incompetent lawyer is causing all the damage. No, it's not. It's the legislation that's causing all the damage. It's the judge who has to enforce the legislation. It's not your lawyer that's causing you problems. It's your inability to retain proper counsel and keep proper counsel that's causing
Okay,
you problems.
I'll say this. I'll say this as an advocate and activist in this movement for as long as I have. I will say I don't want to use the word review because I'm not an attorney. I've never been an attorney, but I will say I've been privy to a lot of case filings and things where I've seen where I'm going, where the hell was your lawyer? Was your lawyer asleep at the wheel? Why didn't your lawyer pick this out or notice that or file this? And I look at the case for 5 minutes, you know. Again, I'm not an attorney, and I can't speak as to why an attorney would or wouldn't do that. But as somebody with just general knowledge, going, good grief, what the hell was your lawyer? Was you asleep at the wheel? Fire the guy. Well, I can't fire him because I already dropped $10,000 on him. Blah 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 blah. And I'm going, God, you need to go in there and chat with your lawyer and say, hey, look, you know, you did not either know about how to practice on my behalf, or you didn't. Maybe you wanted to raise the retainer. I don't know. But I've seen these cases. That's all I'm saying. Go ahead.
Well, you understand, I am very wary when a litigant comes in with a battalion of attorneys surrounding him.
Sure.
That's one of the things that I'm very careful about when I select a client, to allow the client to retain me and pay me and sign my retainer agreement, is who is going to be interfering and who's going to be offering their casual curbside opinions. When a person signs on with an attorney, that person and that attorney form a team. And that team now has how many enemies? The enemy over to the side, the opponent, and then there's a court looking for an order which will, facilitate the receipt of Title 4D funds or VAWA funds or ASFA funds. So it's the two of you against the world. And here comes another moron. Oh, listen, your lawyer's all screwed up. All that does is it breaks up that team. And then that's an opportunity for the vultures to come in and destroy that idiot litigant. I have that happen fairly frequently, and it happens on Avvo, avvo.com. A person wants to second guess his attorney and ask us free lawyers what we think of that attorney's performance. That's a golden opportunity to filch a client away from another lawyer. We could get a check for that. And then that guy is going to then go to another lawyer, let us loose, relieve us of the responsibility for all the damage done to the case, and pay the next guy a bunch of money. That's just that. Maybe that is a large reason, a huge reason why so many people have lost their homes, their money, other property, and their children, because they did not have a cogent plan to execute their case. They thought they could go 10 appearances and hire a lawyer at the 11th hour and everything is going to magically fix itself. I'm here to tell you that that's not how it operates. And if I have a client who has 5 other attorneys, and in fact, I had a client recently like that. There was a lawyer
Yeah,
who
tell
did
us.
appeals.
Yes.
a lawyer who did criminal work, a lawyer that did real estate work, a lawyer that did banking work, and there were 2 accountants. So if I come up with something like, well, there's an order of support, I'll have the criminal lawyer say no. The appellate lawyer will say, no, that's wrong. The 2 accountants will say, no, that's wrong. So I've just been voted down by people who are not specialists in their area. So then the client loses completely. And then, of course, fires me and then hires someone else, fires that person, hires someone else. You have to be a team. And if you don't understand that, well, I don't know how to help you. I certainly won't let you hire me if you walk in here, well, 5 other lawyers told me that it has to be done this way. Have a nice day. The door is down there. That's it. That's how I've remained in practice for 17 years. I sometimes have to be careful who I represent, and it works like a charm.
Thank you. No, this is great. I'm getting comments here. The Congress is unsurpassing of the true seats in Congress right now, called de facto. We are founded as a republic. And then he says, ugh. Okay. We had 5 lawyers who have screwed my husband in 2 cases. Then to try to find one to fix screw ups. Okay, so
you know my answer to that.
Yeah, so we just covered that. Hey, no problem. Thank you for coming on board and being part of this live cast today. This will be shared. I'm also going to put this up on my YouTube as well, in case we violate community standards here at Facebook.com. Seems to me that I have a problem with the carnage of late here on Facebook. But again, I appreciate you coming on board and being part of this and asking your questions and same with you, Mr. Lomtevas. I appreciate you coming on board as well and answering and engaging with me in these very, very faceted topics that many of us are stuck with. We're stuck here.
You're most welcome.
So look, I'm going to scroll back up here, and I get the impression, with all due respect, sir, I get the impression that we have some commenters on here that probably aren't your fans. I've got to put it out there. I am also understanding that they've probably never retained you for services. They don't understand your legal theory, your strategy. So that being said, you as an attorney, you practice. We know that attorneys, they occasionally can get in trouble. And when that happens, the Bar Association and/or the court puts a sanction against that attorney. Have you ever been sanctioned or punished or had any punitive steps taken against you as a good member or as a member in good standing with your bar?
In New York State, I've had 2 complaints that resulted in warnings. There was a case involving a mother who was out of contact with her 2 daughters, and I brought in an expert witness to point out that the mother was completely normal, had no psychological problems, was a totally fit parent, and that the father was doing everything he could to alienate the children in order to stop paying child support. And the adversary and the attorney for the child began attacking my expert, and my expert defended himself in the papers, and I got sanctioned for that because I attached his frivolous writings to my papers. Now, of course, that was a signal sent to my client that I did something wrong and that my client was now supposed to be disappointed in me, was supposed to replace me, that I'm no good, get another lawyer, blah, 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 blah. Quite the opposite. That client stood by me. We moved forward into the case. We appealed the case. We even sued in federal court based on that case. And that was one warning that I received, was because of the defensive statements that my expert witness made in writings in my papers to reunite this woman and her 2 daughters.
Okay, so your expert witness was a child psychologist or unification specialist.
Exactly. It
Okay,
was a child psychologist.
Okay.
And he was attacked by the adversary saying, the adversary said, for example, that my psychologist had no licensure in the state of New York, 3 licenses in 3 states, three other states. And expertise has no geographical boundaries. You can have an expert from anywhere, all right? And we're a free state. Whatever he says, if it's accepted in the community of professionals, it's admissible in court.
Could I get you to pause right there? Look, I could talk about the fry all day long, but I am not an attorney, and I would like you to just very briefly tell the audience what that means.
Well, the Fry Standard talks about how an expert in a field, a learned field, if that expert's opinions and casework or coursework or whatever the report is that he has to write, if it is accepted in that person's community as being valid and reliable, that it is therefore to be considered valid and reliable in a court of law. That's the generally accepted
Right.
standard. And
Right.
that happens to be, basically a psychologist comes in and, yes, I'm a psych, and, here's the MMPI-2, it's accepted in the community, and here's a report, it's accepted, and it's all of its ideas are all accepted, bam, it's admissible, and the person's an expert. The opposing approach is the Daubert approach, where any person who has something learned to say that's helpful to the court is admissible. And that's my cousin Vinny. That's Mona Lisa Vito with her Chevy engines and differentials. And you remember that movie from the 90s? That would be a Daubert expert. New York is a Fry expert. So that's the distinction. Is it really that important? I mean, does it really matter to a person to know whether we're a Fry state or a Daubert state? Yes, maybe to the extent that if the expert is whipping up nonsense, as they do in family court,
I would
really
think it would be
shouldn't
important to know, but let's go back here. I don't want to get too far off this, but so now we have an understanding that it's the general understanding of an expert, or the generally accepted opinion or a meaningful by a meaningful understanding by the scientific community, that this is kind of what everybody agrees to understand.
in that
Now,
community,
right
it's
within
acceptable to the court.
right now, when you've got your guy on here and they're hammering him, and he is the Fry expert, if you will. Go ahead.
Well, he was the retained expert, and the opponent didn't want him to come on the stand because that expert could have ruined the opponent's case. So the opponent's going to attack the expert even before he's qualified on the stand, and this is what happened in the matter, that he is an underqualified individual who doesn't have any background. And my expert wrote in an affidavit that he was practicing psychology when the opponent was in the bathtub playing with rubber duckies. and those rubber duckies earned a sanction. There was absolutely nothing wrong in saying that the opponent was in a bathtub playing with rubber duckies, meaning my expert was very old and had practiced in these kid cases for 50 plus years. It was inappropriate for the opponent to attack him, and the court said it was inappropriate for me to use his affidavit that said rubber duckies. So you want to talk about a hostile court that was hell-bent on preventing a mother from having access to children, sanction me over rubber duckies.
Okay.
Now, I have a case file of 50 cases right now. I must have done hundreds in the last nearly 20 years of practice. Each one has a story. Rubber duckies, that was that one. There were others. We had one expert said bagels in Berlin, that this court is so hostile that it feels like being a Jew selling bagels in 1930s Berlin. That didn't get any sanction. So one court didn't sanction, and the other court did over rubber duckies. The second complaint I received was from a guy who didn't want to pay me $400. He owed $400 on his retainer. And we were in a family court doing a child support proceeding. And he was listening to my adversary, and my adversary was talking about some criminal prosecution that was taking place of my client. So my client accused me of revealing a secret, a confidence. that I told the opponent that he was undergoing a criminal prosecution. Well, guess what? We lawyers look up our clients and we tend to know what they're dealing with. And sure enough, he did have a criminal case, but I never mentioned it to the adversary. I wasn't on speaking terms with the adversary because the adversary wanted to hurt my client, and I wanted to push the case, and I didn't speak with the adversary. So then he filed a complaint against me, and that came down another warning, but 2 warnings. Now, take a notice that the judges sitting on the bench didn't pro hoc into other jurisdictions, didn't break dishes while they were washing them, and they became judges. But us attorneys who cut our teeth with actual practice, oh, sorry, you can't be a judicial candidate because you have 2 complaints in your file. Oh, really? Okay, fine, no problem. Then I'll just continue practicing and not have a problem.
Okay, hold on. Commentator says, put back the veil, Peter. Tell us what really goes on in chambers without parties present, off the record.
Well, that is one part of practice. I talked about this during one previous broadcast, and I'll repeat it here. It's a system of judging that I utterly hate. The judge never read the pleadings, never read the motions, never read the file, never did anything. But the judge calls us into chambers to brief the judge on the case. So I come in and I say A, B, C. The opponent comes in and says 1, 2, 3. And the law guardian or guardian ad litem or whatever they call that in your jurisdiction says X, Y, Z. So what happens is the judge now gets an unofficial review of what's happening, and then begins to cogitate, begins to think, hey, wait a minute, I'm going to have that output. Never read the papers in the record, never held a hearing, but I said something, someone said something, another person said something, and that's it, we're going to do this. A black box. It's a black box. You're tossing something in, out comes something else. And then the judge takes the bench, and this is my ruling, and case is adjourned for another 2 months. I hate that. That's what happens behind closed doors. How do we settle this? Let me see if I could pressure one side to settle, and here's going to be my ruling to try to accomplish that objective. I just can't stand that. To me, that tells me the judge is incompetent when that happens.
Okay, so but it does happen. To answer that person's question, it
All
does
the time.
happen.
All the time.
And is it just you as an attorney, or is it kind of like, do more attorneys like, please don't do this to us, Judge?
Yeah, there are very many of us that cannot tolerate that. Very many. Attorneys are broken down into 2 primary areas. There are the purely privates, and there are the private ones who take state cases for whatever, $80 an hour. The purely privates are going to stand up and say, Your Honor, we really don't want to discuss the case without a stenographer present. But then the court will come back and say that you don't have a right to a stenographer. If you don't answer my questions, I'll take
I'm glad you said that. You know what? I have heard this, so many times about this. You got to pay for one, don't have one. I thought, when I was a student there taking business law, and I took an intro to law at Green River Community College in Auburn. I thought that this was just something that the court did. I did not realize that you have to pay out the ass.
Yeah, between $3 and $4 per page for a transcript. Yeah, it could be thousands of dollars for a transcript. And the hell of it is that the majority of these decisions are made in chambers without a transcript. That's how it's done. It's done in chambers behind closed doors. We're basically pooping up the judge to get the judge to say something. And it kind of makes sense. I mean, if I worked 9 to 4:30, I wouldn't want to read papers before 9 o'clock or after 4:30. It's a great comfort zone. The lawyers brief me up, takes 10 minutes. Aha, I know what I'm going to do. I swoop into my courtroom. This is going to be the result, and we adjourn. Very neat. And if I can delegate half of my caseload to my court attorney to dispose of adjournments, I could have an early lunch. And then in the afternoon, sit and jaw jack with the employees, and then at 4:30 go home and not read a thing, not do a thing. I can't stand those chamber conferences.
But I do have to say, though, or at least I have to ask, are there times where it becomes advantageous. Maybe you, counsel, the judge, sit down and talk about the thing, whether that thing be a book, a car, property, custody, visitation, grandma's will, whatever it is. You talk about it with the judge in judge's chambers. You get it all ironed out, head back into the courtroom, and get her done. Could that not be advantageous?
Well, you're talking about a super honest, super professional judge, but the super honest, super professional judge would have a court reporter taking transcripts, taking minutes of any chamber proceeding. In other words, let me put it to you this way. We regulate our judges very, very heavily. And one of the very heavy regulations is every utterance coming from the judge's mouth gets recorded on a piece of paper that's distributable to everybody and anybody. That's what a public proceeding is. To go inside of a chambers and sit in the back and be absolved of that spotlight, I mean, you're opening the door to all of these issues that everybody's complaining about. How did I lose my kid? Well, probably through a backroom chamber conference. Somebody important made an allegation, oh, you smoke pot or you do drugs. And the next thing you know, there's a temporary order of custody to one side and suspended visits to the other. I would rather have the protection in there than to trust somebody. I trust nobody.
Okay, but when we're talking about, go back to that. We're talking about order of protections, right? Would you want to take a judge aside and be like, look, Your Honor, my client's got no priors, no criminal history, no nothing. Kind of like off the record, but on the record, can we do like a limited thing? Why are we going to screw my guy for the next 10 years?
But what if the prosecution says the opposite? And what if the prosecution lies? What if the prosecution fabricates a fact pattern that doesn't exist? I don't have a court reporter to give me paper output that I could use against the prosecutor. It's never the judge and me. Judges are prohibited from initiating or having ex parte communications.
Great question, Angela. Oh, that's so swinging dick right there. So we can refuse to have our attorneys attend these conferences.
Yeah, you try that, the court will sanction you. When the court orders lawyers to go into chambers and you pull the lawyer back, you can expect the court to violate you or to contempt you.
Okay, so I didn't even know that. I did not know that, and I've seen lots of court. Great question, though. So real quick, and then I do want to get going for a little bit. But let's close out with this. So when I'm your client and I'm telling you, look, I want everything done in court. I don't want you to go meet with her lawyer because I don't like he's a shady bastard. I don't like him. He's
Well, then the client is putting me into a serious conflict. Do I follow my client's demands or do I follow the judge's demands? If I don't follow either, I lose. And of course, if I lose, the client loses. So in my judgment, I'm going to go where the judge tells me to go, and I'm going to demand of the court to have a reporter present. The court will tell me no, and then I'm sitting there stuck. If I don't talk, I diminish my client's position. I'm going to have to talk, and I'm going to have to counter what my adversary is saying, and it can get quite ugly, and then the judge comes up with some black box output.
That's a violation of our rights, correct?
You're seeing the essence. You're catching those little points where that's where it takes place and that's how it takes place. But the court controls. The court pulls people into chambers, formulates its opinions. That is one of those areas. There are many of these, but we're exploring one. But if that client instructs the attorney to stay out, then the judge could take an adverse inference, and then the client is screwed. And then, so I have to kick in. I have to kick in and say, "Be quiet. I'm going in there. I'll tell you what happens." And who knows what'll happen? I may walk out and be the winner. I may walk out and be the loser. But I have to fight like hell, and there's no record made.
Right.
And then the court comes up with a decision that doesn't have a basis in the record. And in many jurisdictions, you can reverse the decision if there isn't a sound and substantial basis in the record for something. Usually, the more inept judges do this to try to sway the thing, that unlevel the playing field to make the winner give in and make the loser the winner. The whole idea is to make them kind of come to a settlement. And not all cases can be settled. Not all, my heavens, there are so many cases that cannot be settled. The drug addicted alcoholic is probably not the better primary parent for a child. Or maybe the client who works overnight may not be the better primary. I mean, there may be issues that a court has to resolve according to the law and not just simply force a settlement. There are some jurisdictions that force 50-50 settlements, some jurisdictions that force alternating weekend settlements without looking at the facts. So if the clients don't settle, they get the cookie cutter. And sometimes the judge applies the wrong cookie cutter.
Oh, we see that. We see that all the time. Hey, look, we could go for quite a bit longer if we wanted to, but I want to go ahead and close this out now. Mr.
Okay.
Lomtevas, you know what? It has been a pleasure speaking with you. I mean, I really appreciate you engaging with me today, and I also want to say to the audience, I appreciate everybody coming on board and talking to us as well. Again, this is not my regular profile. I am in jail, kind of. Okay. So you got to be very careful sometimes with Facebook's community standards. But look, I think we're gonna have a couple more of these. I do want to get some other folks on to talk about not only their experiences but their knowledge as well. Mr. Lomtevas, I know you're working on some of your own projects. If anybody wants to reach out to you, how could or would they do that?
Well, you look up my last name and Google it. You'll find me immediately. You'll find my website, get my phone number, and or reach me through Facebook, like you're on Facebook right now. You should see my name clearly, and I'm always responsive.
All right. Mr. Lomtevas, I appreciate for your time coming on here today. God bless you. Keep up the good work there. And you know what? It's good to see that there are people that are outspoken and knowledgeable about the issues that America's families are facing.
You're most welcome anytime.
Thank you, sir.